Over the last decade or so, with corporate scandals like Enron overseas, the New Zealand finance company collapses, the issue of directors' duties has become a very prominent one. Directors need to be aware of the standards the law places upon them and to make sure that they are well equipped for the role. If they aren't aware of their obligations, then there could be dire consequences both for the investors and also for the directors themselves. For example, the directors of some of the failed finance companies included former cabinet ministers, and yet they seem to lack understanding of the obligations that they had under the law, and they were made liable as a result. This is a big issue for New Zealand business. There are about 600,000 New Zealand registered companies. Most of them are very small, one or two shareholders, usually only one director, and I suspect most of those directors don't give a second thought to their legal obligations, the obligations they owe to the company and their investors until things start to go wrong. What is the best way to enforce directors' duties? This can be done by the state through state bodies like the FMA, the Financial Markets Authority, and that is quite appropriate where you've got large businesses with lots of small passive investors who have little knowledge or interest in what's going on within the company. On the other hand, most businesses in New Zealand are very small and the investors are often quite closely linked with the businesses. In that case, they have levels of motivation and understanding which outside parties simply would not have, and in that case it's quite appropriate that they should be left to largely take care of themselves. Another issue is exactly who do directors owe their duties to? Exactly whose interests are they taking into account? Now, conventional wisdom and modern management theory would tend to say it's all the stakeholders, the various stakeholders involved in the business, but the courts have tended to say, they've tended to take a narrower, some might say a more simplistic view and say the job of directors is to maximise profits for the enterprise itself. Are the legal duties pitched at the right level? Are they too tough, which might discourage qualified people from accepting the role? Or are they too lenient on directors, which might place an unacceptable risk on investors? And of course, the answer to that depends on which side of the fence you happen to be. My research into the decided cases suggests that they are pitched at about the right level, which means that investors, you need to be aware that you don't have an automatic right to be covered if a company fails. The directors won't necessarily have to compensate you, but directors, be aware that the possibility of liability is there if you don't act carefully, competently and honestly. Be aware of your obligations as a director, and if you're not sure, then seek legal advice. Don't assume that these obligations only apply to directorships of big companies. They don't, they apply to every company. Even if you delegate much of the day-to-day management of the business to others, you remain responsible. There is no such thing as a silent director. Most corporate managers will know about limited liability, which protects shareholders from liability for corporate losses. But if those shareholders are also directors, which they often are, then those directors could be liable for any breaches of directors' duties. It's not enough just to be honest as a company director. There also needs to be a certain level of care and competence.